Wait, please, Your Lordship.
Yes.
Lord, may I pray for listing of a repetition tomorrow? A connected repetition is already fixed tomorrow, my Lord.
All right.
Highly appreciated.
May I please, Lordship? Lordship, this matter was last posted in 24/7, this promotion, and on that day it was adjourned on my prayer. They wanted to bring some additional document by way of filing additional affidavit. So I filed the affidavit, Lordship. It will be posted any date in the next week,
Next week.
any date, Lordship.
Motion for motion.
Motion.
Next Wednesday.
Next
May
week.
please, your Lordship. Lordship, I'd like to mention item number 1 for adjournment.
Hmm.
Lordship, I'm being led by my senior in this case. However, he is on leave, Lordship.
Prayer for adjournment of admission hearing of this matter has been made on the ground of non-availability of Mr. K.K. Mahanto, Lanet Senior Counsel engaged in this case. So since the prayer is not opposed, same stands allowed. Let these matters be listed again for admission.
Lordship, could it be on next week? It is actually
No,
a little
after 2
urgent.
weeks, after
Lordship,
2 weeks.
Lordship, kindly consider my prayer, Lordship. It is regarding cutting of a hill, Lordship. My house is exposed. And
After 2
there could be,
weeks.
Lordship, next week, Lordship, kindly.
No, then you do it today.
Lordship, kindly next week. It is, I'm not well, Lordship. That is why I'm not even, I was considering that I would do it, but
We have other business next week, so not possible. You do it today, I will hear you.
then Lordship may not fix the date. I'll much appreciated.
Adjourn. Just adjourn.
May I please, your Lordship, I beg to mention for unlisted matter for today, Lordship. Lordship, matter is very urgent because
What is the matter?
Lordship eviction in Silsako. Lordship, petitioner land is not within the area which is demarcated by the authority. But his house is partially destroyed, Lordship, and his name is not within the list.
Tomorrow morning,
Yeah.
the first item, please.
My lord, I beg to mention one repetition for admission,
Hmm.
and it was listed lastly on November 22. Any date, my lord, next week or next
After 2 weeks.
Well,
After 2 weeks.
date may be given, my lord.
I'm praying for, listing of orders matters. Listing of orders matters. Lordship.
What order?
Lordship, notice was issued, but it is not listed thereafter. In this case.
All right.
For admission, I think.
May it please your lordship.
Yes.
My lord, I am the president of the Gaon Panchayat, my lord, and there is a no confidence motion against me. And this no confidence motion, my lord, is a clear violation of section 15, my lord. And also section 17(3), my lord. It is a clear violation. My lord. So record was actually produced before this honorable court, my lord.
So it is for disposal today. Mr. Chaudhary, final disposal.
I have no objection. My lord, if the record, it's a very short point, my lord. My lord, annexure page 16 is the my lord notice.
Page 16, annexure.
Annexure A. Annexure A, page 16, my lord. That is dated 21/12/2022. That was a requisition, my lord. Addressed to the secretary.
Yes.
Then, my lord, secretary convened a meeting, my lord. Page 23, page 21, my lord. Page 21, my lord. Without placing the matter to the president, my lord, president of the Gaon Panchayat, my lord, directly, my lord. That is page 21, may I read it, my lord. Respectfully beg to inform you that with reference to the subject cited above, that the 18 numbers of guard number 7 is no mention. Therefore, executive meeting is required to be convened in 15 days from that of submission. Therefore, executive meeting is convened on 29/12/2022. Thursday, 22. Therefore, the pair should issue. So that secretary issue a notice for meeting, my lord. Without placing before the my lord, president, my lord. So he himself, my lord, your lordship, kindly, it will be very clear from the, my lord, may I read the page 23, my lord, in vernacular position, my lord. সন্মান সহকাৰে আপোনাৰ জ্ঞাত জনোৱা হয় যে উপৰোক্ত উল্লেখ কৰা বিষয়ে মৰ্মে যোৱা 21-12-22 তাৰিখে চানি গাঁও পঞ্চায়ত অঞ্চল হৈ আপোনাৰ ওপৰত অনাস্থা প্ৰস্তাৱৰ এখন আবেদন পত্ৰ দাখিল কৰিছে। সেয়ে অসম পঞ্চায়তী ৰাজ আইনৰ ইমান শেহতীয়া সংশোধনী আবেদন দাখিল কৰা তাৰিখৰ পৰা 15 দিনৰ ভিতৰত কাৰ্যকৰী সভা আহ্বান কৰিব লাগে। গতিকে অহা ইমান তাৰিখে বৃহস্পতিবাৰে দিনৰ 11 বজাত কাৰ্যকৰী সভা আহ্বান কৰা হৈছে। সেয়ে আপোনাৰ উপস্থিত অনুমোদন পেশ কৰা হ'ল। So that was the meeting called by the my lord secretary, and that meeting on that my lord did not take place, my lord. He referred the matter to the my lord Anchalik Panchayat. And Anchalik Panchayat, my lord, executive officer convened a meeting. That page 31, my lord. Page 31, my lord. So first of all, my lord, the executive officer has no authority, my lord. He has no jurisdiction to convene a meeting, my lord. He has no authority, my lord. Our division in government also, my lord, it can be done by the president of the. If it is referred, my lord,
Meeting is always convened by the secretary. It is done with the approval of the president.
no, my lord,
But other points may be different.
my lord.
President will never convene a meeting. That's the settled law. Meeting is to be always convened, all meetings
No.
are to be convened by the secretary.
That is, my lord, so far is Gaon Panchayat, my lord. Panchayat is concerned. When it is go to the Anchalik Panchayat, my lord, secretary, there is no secretary in Anchalik Panchayat, my lord. So at that,
No, Mr. Mohan, on your first submission,
my lord,
if I have understood correctly, you
My
said
lord.
that the secretary convened the meeting, which was really-
secretary convened the meeting without placing, my lord.
Huh.
Secretary convened the meeting with the my lord approval of the Panchayat president, my lord. That is first round, my lord. So very, my lord, initial that need, all right, that is a technical difficulty. It is addressed to the secretary,
Mhm.
but it has to be placed before the, my lord,
That's right.
president. President will say that he will convene a meeting. So meeting will be convened by,
So your case is that the requisition was never placed before the president.
my lord.
So the president has 15 days time, is it?
My lord, 15 days time.
If the president does not convene it within 15 days, then within
No.
next 7 days, the AP.
3 days.
The next 3 days.
It has to send to the Anchalik.
Yes.
So Anchalik, my lord, in Anchalik Panchayat with 3 clear day notice, it has to be convened by the president, only president convene the meeting. That is the judgment of our High Court, my lord.
Hmm.
So that is the lack, my lord. You are asking, in fact, my lord, there is no 3 clear days notice also. Page 31, your lordship kindly see. Here, my lord, meeting was convened, my lord, because in meeting pursuant to the, in Panchayat, my lord, it was not held, my lord. Although it was fixed by the secretary, on that day, it was not held. Then he sent it to the Anchalik Panchayat, and Anchalik Panchayat on notice issued on 6/1/2023. Meeting held on 9/1/23. So if it is excluded, my lord, first day, then 3 clear day notice is not there. So even then, my lord, he has no authority to, my lord. So that is my case.
And 9/1 meeting was held and resolution adopted.
Yes.
Which is the, which number resolution, number? Number
Yeah.
1,
Page 32, my lord.
yes. There are number of resolutions.
My lord.
Which is the resolution?
Resolution 3, my lord.
Page 33.
Page 33, my lord.
Seven is to 0.
0.
7 members voted in favor of. the
Yes, my
resolution. All right, so what are your submissions?
My submission, my lord, first of all, my lord, it was never placed before the Panchayat, my lord, Panchayat president, against whom, my lord, it was no confidence for, my lord. And there was a clear violation number 15/1, my lord. And my lord, thereafter, my lord, it was sent to the Anchalik Panchayat, my lord. In Anchalik Panchayat, my lord, 7 cleared, 3 cleared,
When was it sent to AP?
my lord.
When was it sent to Anchalik Panchayat?
Anchalik. Page 29, my lord. Sorry, page 28 and 5-1. Page 28, my lord, annexure D. Madam Secretary of the Gaon Panchayat, my lord.
Yes.
So now, my lord, your lordship kindly see that notice, my lord, that is 6-1, my lord, that was a notice issued by the executive officer, my lord. So first of all, my lord, that again I am submitting, my lord, executive officer, my lord, he has no authority to declare the call for the meeting, my lord. And secondly, my lord, that she cleared a notice also not being. So regarding that,
Three clear days is required under 17(3).
7. So regarding, my lord, power of the executive officer, my lord, and there is a judgment of our High Court, I place before you, actually. In 2018, my lord, 1 GLJ 339.
Yes.
Para 7, my lord. And that is also, my lord, there is a judgment of division bench, my lord. It is the same judgment, my lord. So that order was sent, my lord.
What does it say?
That says, my lord, the act that this meeting was not convened by the president of the president, but by the secretary of the instructed on instruction of the president. Therefore, lordship language is judgment person. Last 2 para, my lord. Another judgment. That's me. Para que no sé.
Yes.
So another judgment, my lord, that is para 19, my lord. We can see. Para 19, my lord.
Yes.
So that judgment, 2016 1 GLP, my lord. So in these 2 judgment, my lord, clearly mentioned that, my lord, the executive officer has no, my lord, he that is has to be in actually conscious president, not the, my lord. Regarding 3 clear day notice, my lord, there is a.
Yes, that's all.
Regarding.
So your main plea is want of jurisdiction
By
of the executive officer.
My lord. And 3 clear day notice also. 3 clear day notice, my lord, that there is not no clear day. That is 17.
In Hafizur Rahman, which paragraph you are relying upon?
Hafizur Rahman, my lord. Last portion of the para, there is no para in this case. Very interesting, there is no para, my lord. Running page 6, my lord. Last one. It is therefore absolutely clear that the 3 clear day notice has to be given to the special meeting. This was not given by the communication dated so and so. So that para page 6, my lord. That's my solution.
Yes. Yes, please.
My lord, kindly come to paragraph 5 of the writ petition. At page 8.
Yes.
That the petitioner states that the requisition dated 21/12/22 was not properly delivered to the petitioner. Rather, Secretary of the Gaon Panchayat himself fixed the date for meeting on 29/12/22 and then placed the matter by letter dated 23/12/22 before the petitioner for her appearance and approval. Somali himself says. The petitioner refused to accord the approval on 27/12/22 as the secretary himself fixed the date of meeting. My lord, will kindly come to section 15 for a moment. There is no requirement that the president should convene the meeting, my lord. It is the duty of the secretary to convene the meeting with the approval of the president. Subsection 1, first subpara. Such a meeting shall be specifically convened by Secretary of the Gaon Panchayat with the approval of the president. So, my lord, fixing date and seeking approval has to be by the same
The
process.
first ground, I have seen it, even the communication of secretary
Yes.
mentions it. That
Yes.
it was
Now, my
clear.
lord will kindly
What
come.
about the second
I'm
ground?
coming. Yes. My lord will kindly come to page number 23, the vernacular portion. At times, my lord, translation creates problem.
Yes, yes.
So he admits about this. Later, kindly see, my lord, the endorsement. Onumudon Dian Hol. The president refused to give approval. So now, my lord, therefore, it does not lie in his mouth to make the argument. Kindly
No,
see.
that part you need
Yes,
not labor.
okay.
President's approval, you need not labor.
Yes.
That is now established.
Now, then my lord will kindly come to section violation of 3 clear days notice, and it is the duty of the president of the Anchalik Panchayat to convene the meeting. There, my lord will kindly come to the affidavit filed by the president Anchalik Panchayat, my lord. Please come to page number 75, my lord.
Page number 75.
Yes. That's part of the affidavit filed by the Anshalik Panchayat President,
What is the date of the affidavit?
5th of January 2023. An affidavit was filed on 7th of September 2023. Annexure A.
Yes.
Yes. Kindly see, my lord, it's a communication by the president of the Rupohihat Anshalik Panchayat. Date is 5th of January 23.
Hmm.
Regarding letter dated so and so, it is hereby informed you that a letter received from Secretary Khaidoria Gaon Panchayat by letter dated so and so. According to that letter, no confidence motion raised against the president of Khaidoria Gaon Panchayat, namely so and so. So for discussion about the no confidence motion, you were told to convene a special meeting on 9th of January 23 in your office chamber within the office hours. So it is the president who has taken the decision to hold the meeting.
Have you seen those judgments he's relied upon?
No, my lord, no, those no, lordship will have to, let us go by what is the clear language of the statute, my lord. Now it is the president who has to convene. Now, my lord, president has convened the meeting, only communication has been made by the secretary.
Mr. Chaudhary, this point appears to have been dealt with in the division bench as well as the single bench judgment.
Okay,
Those cases also I find subject to what you say.
yes.
The president asked the executive or chief executive to convene the meeting, and then he convened the meeting. Those were set aside.
No, my lord, with all respect, my lord, the legislative intent is very clear. End of the day, it is a democratic process, be it section 15, be it section 17. The idea is whether the president enjoys majority. Now, to test that, my lord, certain procedure has been prescribed. Now, my lord, this prescription, be it 15, be it 17, it has to be construed in that context. These are not substantive provision, my lord. These are all procedural parts. Yes. Now, what is the substantive provision? It is the president who will convene the meeting.
So you are saying that once the president loses the majority, little here, little there doesn't matter.
Yes.
That view will not be possible.
Your lordship has taken that view, my
The
lord.
bench has already, on this particular point.
No,
has
no,
already-
no, my lord. I'm going a little further. What I'm trying to submit is the legislative mandate is it is the president who will convene the meeting. President has convened the meeting. President on 5th, he has taken a call to convene the meeting only for the purpose of this ministerial act of, notifying parties. It has been done through the secretary, my lord. It is the president who has convened the meeting. Kindly see, my lord. Kindly go by the language of that letter at page 75. So for discussion about no confidence motion, you were told to convene a special meeting in your office chamber within the office hours. So the substantive decision to have a no confidence motion, it has been taken by the president. The ministerial act of conveying the decision was left to the secretary. Now, I think it will be too much to stretch the, my lord, legislative intent as far as section 17 is concerned, 15 is concerned, my lord. Had it been a case, my lord, the president is not in the loop, president is nowhere in the scene, and the secretary convenes, yes, then it is yes. My lord, every decision has to be seen in its own facts. Now, in my humble submission, my lord, there is substantial compliance of.
Mr. Chaudhary, do you have the judgment?
I have heard it while my learned friend was reading that paragraph, my lord.
That is the troubling.
Huh?
I may have some, if it was only the single bench, probably I could have disagreed and
Yes,
put
yes.
it up, but this is the division bench judgment. Please read para 12.
Yes, the records produced in the present case, however, reflects that the president of the Hailakandi Anshalik Panchayat had ordered for arrangement of the meeting, but did not actually convene the meeting herself. But on this aspect, a clarificatory observation may be necessary. Memo dated so and so convening this special meeting was signed by the secretary, but surprisingly, a replica notice with the same memo number is produced by the learned counsel for the private respondent, but the signatory of this notice is the president of the Anshalik Panchayat. The original records produced by the departmental lawyer reflects that notice was issued by the secretary, and endorsement of the notice receivers are found to be appended to this notice. This suggests that secretary was the genuine noticee. Secretary was the genuine notice. What exactly? And the other, this printouts at times are very problematic.
Yeah,
This suggests that secretary was the genuine noticee. Conspicuously, the other notice with the same memo number was signed by the president. But here, none of the notice receivers had appended their signatures. Therefore, possibility of an attempted interpolation of real note. Here in this case, my an attempt was made to improve the case. That we are.
No, para 13 is very clear on
Okay.
the point.
However, what is important is that president of the Anshalik Panchayat had not convened the meeting herself, but had ordered arrangement of this special meeting through her endorsement dated so and so, and acting on such an endorsement of the president, secretary had issued a notice to convene the so and so. Of course, my
So,
lord.
Mr. Chaudhary,
I follow.
let us cut the long matter short. Your argument that once the Anchalik Panchayat president issues an instruction,
Hmm.
for all practical purposes, it should be treated to have been a meeting initiated at her or his instance.
Yes.
That argument is very attractive. If it was only the single judge's order, maybe I would have given my opinion and maybe referred the matter to a larger bench. But this is a division bench judgment. I have no option to do
It's
it.
binding on your lordship. And from that stage, the things will continue.
You
I
can
follow
address the court on that.
No,
This
no, my
court
lord,
can't say I'll not-
I can't even argue for reference of this division bench. Division bench
can't.
is binding on your lordship.
That's what I was observing.
No, that's okay, my lord. Why should we, I mean, this,
So if it was only single bench, then maybe you could
lordship
have,
would have referred
you
the
could have
matter.
had a persuasive value in the court and then,
Mhm.
but division bench, what to do? This is precisely on the point. Precisely on the point. Same, absolute same. So the ratio is very clear. And it is applicable to the facts of this case.
Correct.
What is
In
the
fact,
option-
more of the same fact.
What is the option left?
Anyway, since the division bench view is there, my lord, I cannot call.
That's the problem. You cannot argue, this court cannot.
At least from the stage of my lord, the president convening the meeting, we'll start from that stage, my lord.
That I'll clarify that this order
Yes.
will not come in the way of
Yes, yes.
in accordance
Yes,
with law.
yes.
What do you have to say? He has pulled up a trump card. You can't have anything to say. now. All right.
No, my lord, when we are bound by
I
the
agree, I
precedent
appreciate.
system, yes.
I appreciate, but then what to do? You are appearing for whom, Mr.
I'm
Chaudhary?
from the, for the, my lord, the requisition is respondent 7 to 13, huh? 7 to 13.
Take down, heard Mr. K.K. Mountain, as a senior counsel assisted by Mr. R. Ali, and counsel appearing for the writ petitioner. Also heard Mr. K. N. Chaudhary, learned senior counsel assisted by. Yes, assisted by S. Alam for the caveators, respondent numbers 7 to 13. Then you write Mr. S. Barua. Learned government advocate Assam is present on behalf of respondent number 2. Whereas Mr. S. Datta, learned standing counsel, PNRD Department Assam, has appeared for respondent numbers 1, 3 and
1, 3, 5, and 6.
1, 3, 5 and 6. Who is for the respondent number 4? Mr. M. H. Talukdar, learned counsel is present for the respondent number 4. By filing this writ petition, the former president of Saidaria, SAIDARIA, Saidaria Gao Panchayat under Rupahihat Anchalik Panchayat of Nagaon Zilla Parishad has approached this court assailing the resolution of adopting the no confidence motion brought against her in the meeting held on 9/1/2023, thus removing the petitioner from her office. First, the impugned resolution number 3 contained in the minutes of meeting held on 09/01/2023 is assailed primarily on 3 counts. Firstly, the secretary of the Gao Panchayat never placed the requisition dated 21/12/2022 submitted by 8 members of the GP seeking approval of the president of the Gao Panchayat for convening this special meeting, but had directly sent the requisition to the Anchalik Panchayat president. Full stop. Secondly, it is the president of the Anchalik Panchayat who was alone competent to convene the meeting, convene the special meeting, but in this case, the meeting was convened by the executive officer of Rupohi Anchalik Panchayat, that is the response number 5. Although he did not have any authority or jurisdiction under the law to do so. Hence, the resolution is vitiated, impugned resolution is vitiated on such count alone. Thirdly, 3 clear days notice as required by section 13(3) of the Assam Panchayat Act 1994 was not given in this case. Full stop. Next paragraph. The facts of the case lie in a narrow campus on 21/12/2022. 8 members of the Gao Panchayat had submitted a requisition before the secretary of the Saidaria Gao Panchayat. Ekhine agot dibo, has been assigned the fact of episode submitted a representation dated 21/12/2022 before the secretary of the Saidaria Gao Panchayat. That is the respondent number 6 hearing with a request to convene a special meeting for discussing the no confidence motion proposed against the petitioner who was the president of the Gao Panchayat. Full stop. After the 15 days period after the expiry of 15 days from the date of receipt of the requisition, the respondent number 6 had forwarded the same to the president of the Anchalik Panchayat for taking appropriate action in the matter under section 15(1) of the Assam Panchayat Act 1994 for convening the meeting to discuss the no confidence motion. Full stop. It is clear that on 5/1/2023 itself, the president of the Rupohi Anchalik Panchayat, that is the respondent number 4, had forwarded the matter to the respondent number 5, that is the executive officer of the Rupohi Anchalik Panchayat, with clear instructions to convene the meeting on 9th of January 2023 in his office chamber and within office hours. Accordingly, notice dated 6/1/2023 was issued by the respondent number 5, convening the meeting on 9/1/2023. Full stop. In the said meeting, by resolution number 3, the no confidence motion brought against the petitioner succeeded on the basis of casting of votes at the ratio of 7:0 vote in favor of the motion. Accordingly, the petitioner stood removed from the office of the vice president. Full stop. Next paragraph. By referring to the decision of the division bench rendered in the case of so-and-so versus so-and-so, 2018 bracket close 1 GLJ 339. Mr. Mohanta submits that the assailed on grounds so-and-so submits that the respondent number 5 would not have submits that it was the respondent number 4 who was alone authorized to convene the meeting, and therefore the respondent number 5 did not have any authority under the law to convene the meeting. Full stop. But in support of his above argument, Mr. Mohanta has also placed reliance on the decision rendered by the learned single judge in the case of Anwara Begum versus State of Assam and others, reported in 2016. Bracket of 1 bracket close GMT 648. Full stop. By placing reliance on an unreported decision of the division bench rendered in the case of Hafizur Rahman versus State of Assam and others, dated 17/12/2021. The third bracket of read appeal number 189 of 2021. Third bracket close. Mr. Mohanto submits that it has been held that the requirement of 3 clear days notice under section 17 bracket 3 of the Assam Panchayat Act was mandatory in nature. In the present case, since the notice convening the meeting was issued on 6/1/2023. Convening the meeting on 09/1/2023 was issued on 6/1/2023. It is evident that there was no clear 3 days notice in this case. As such, Mr. Mohanto has prayed for setting aside the impugned resolution. Mr. Chaudhary has argued that the first ground urged by the petitioner is totally untenable in the eye of law, since it is the pleaded case of the petitioner that she had declined approval when the requisition was placed before her by the secretary. With regard to the other 2 grounds, Mr. Chaudhary has argued that since it is a democratic process, once the president of the GP loses the confidence of the majority member, he or she would not have any authority to continue in office. To that extent, Thomas submits Mr. Chaudhary, mere procedural irregularities should not be sufficient ground to restore the candidate back in office once he or she has lost the confidence of the majority of the members of the GP. Mr. Chaudhary has, however, fairly submitted that the decision rendered in the case of so-and-so versus so-and-so, a DB judgment, would have direct bearing in the outcome of the present proceeding. Mr. S. Datta, Learned Departmental Counsel, has produced the records. I have perused the same. At the very outset, it must be pointed out herein that materials on record clearly goes to show that the respondent number 6 had placed the requisition seeking approval of the petitioner on 23/12/2022, but she had declined the same on 27/12/2022. It was only thereafter that the secretary of the Gaon Panchayat, that is the respondent number 6, had forwarded the same to the president of the Anchalik Panchayat, that is the respondent number 4. Full stop. As such, it is not a case where the respondent number 6 had acted on his own and without making an attempt to seek the approval of the eighth petitioner. Full stop. However, what is significant to note here is that the respondent number 4 did not take any step to convene the meeting, but had merely instructed the respondent number 5 to do so. Full stop. Accordingly, the meeting was convened by the respondent number 5 on 9/1/2023. Full stop. In the case of so-and-so versus so-and-so, a DB judgment, it has clearly been held that the president of the Anchalik Panchayat, not having convened the meeting herself, but having ordered arrangement of the special meeting through her endorsement made in the file, would not meet the requirement of section 15(1) of the Assam Panchayat Act 1994. Accordingly, the resolution adopted in the specially convened meeting against the president of the Gaon Panchayat was set aside. First step. Similar view has also been taken by taken by the learned single judge in the case of Anwara Begum bracket Supra, wherein the meeting convened by the executive officer of the Anchalik Panchayat, section 15(5) of 15(3)(1). Anchalik Panchayat, executive officer of the Anchalik Panchayat was held to be impermissible. Full stop. The learned single judge has further observed that permitting the executive officer to convene such meeting would go to emasculate, emasculate, emasculate the rigors of the provisions of section 15(5) of the Act of 1994. Having held as above, the resolution adopted in the meeting was quashed. Full stop. Next. In the case of Hafizur Rahman, bracket Supra, the division bench has expressed a clear opinion that the requirement of giving 3 clear days notice under section 17 bracket 3 bracket close of the Act of 1994 is absolute. Yeah. Is absolute, and any violation thereof would be at the cost of invalidity. And therefore, any violation in respect thereof would be at the cost of invalidating the proceeding itself. Having regard to the ratio laid down in the decisions relied upon by Mr. Mohanto and applying the same to the facts of the present case, this court is of the unhesitant opinion that the procedure adopted by the authorities in convening the special meeting held on 9/1/2023 in clear violation of the mandate of section 15 bracket 5 bracket close, read with section 17 bracket 3 bracket close of the Assam Panchayat Act 1994. The impugned resolution dated so and so is therefore set aside. It is ordered that the petitioner shall forthwith be reissued in her office. First of necessary order in respect thereof would be issued by the concerned authorities within 7 days from the date of receipt of a certified copy of this order. Before parting with the record, it is, however, made clear that the present order of the court shall not come in the way of a fresh requisition being submitted by the members of the Gaon Panchayat in accordance with law. If so advised, first of, if such a requisition is submitted afresh, the same shall be acted upon in accordance with law and brought to its logical conclusion. Writ petition stands allowed parties to bear their own cost. Deeply.
Next to Amayal.
Item 3. At the line 8.0, the applies squarely applies to so and so. Moreover, the decision of the division bench rendered in the case of so and so Supra would lay down a binding precedent for this court to follow. Moreover, therefore, the decision laid down would lay down a binding precedent.
Yes, Your Lordship. On 23rd, Your Lordship had directed us to file our affidavit in reply within 2 weeks, Your Lordship. I'll take some more time, Your Lordship, to file the affidavit, Your Lordship. In the absence of the affidavit, the matter may not be heard. Your Lordship. There are certain allegations against the petitioner. We need to reply to that, Your Lordship.
My lord, we have serious objections to that prayer, my lord. Normally wouldn't have made. Now, my lord, the gentleman called Apurva Vallabh Goswami, he, my lord, he is espousing somebody else's cause. What had happened, my lord? One of the complaint which has been filed by the petitioner before the CVC is, my lord, that a particular contract regarding construction of a boundary wall was not given to a particular contractor, whose cause now there he is espousing, my lord. Because, my lord, the rate was 35% below the schedule of rates. Now, my lord, who is he, my lord, first of all? That contractor is the primarily injured person. Lordship knows in SP Gupta's case, Honorable Supreme Court has said by an act of omission or commission, my lord, it can ensure two types of injury. One is a primary injury and other is a secondary injury. The primary injury is always suffered by the contractor. And as a member of public, my lord, he suffers the secondary injury. Now, Supreme Court says when the person who suffers primary injury declines to go to the court, then at the instance of a person who has suffered the secondary injury, a writ petition is not maintainable. In any case, my lord, his complaint is being looked into. My lord, nobody has fallen from heaven, my lord. Kindly see, my lord, he is filing complaint in the name of his cook. Huh? Yeah, how is a person, my lord, who can maintain a writ petition? A person who has an enforceable right.
So you are appearing for whom?
I am appearing for respondent number 5, my lord, against whom the allegation has been made. 5 and by 6 he has been made by name. One Keshavananda Bora, my lord, who is his cook. In his name complaints are filed. It has so transpired.
You are the petitioner. Why are you seeking time?
No, Your Lordship, we need to file a reply to that in the sense, Your Lordship, that the cook's email complaint, Your Lordship, was verified by the Central Vigilance Commission. Only when notices were issued on 12/6/2023. Thereafter, there was a secondary mail which came from the other person, Your Lordship, stating that. Yes,
Mr. Sharma, we'll go to the
Yes,
facts.
yes.
Who are you?
I'm the petitioner here, Lordship, that my legal right has been violated in the sense that my complaint before the respondent number 5 was not looked into by respondent number 5. Thereafter, I was constrained to approach respondent number 1, 2, 3, and 4 against.
What was your complaint?
Yes, Your Lordship, my complaint, Your Lordship, is at page 23, Your Lordship. It's against corruption by officials of Numoligarh Refinery Limited. In this regard, Your Lordship, certain accusations have been made against me, Your Lordship, in the affidavit in reply by the respondent number 5 and 6. Need some time to reply to that. We're in the process of finalizing.
First of all,
Yes,
let me
yes.
understand.
Yes,
the
yes,
case.
yes, Your Lordship.
He is raising an
Yes,
objection.
yes, absolutely.
I must
Yes,
decide
yes.
whether time should be granted
Yes.
to you or matter should be closed.
Yes, yes,
So first you succeed in that.
yes,
If you succeed,
yes,
then time and then how much time?
yes,
Let's
yes.
go one by one.
Yes.
What is this complaint? Who has made this complaint?
The petitioner has made this complaint, Your Lordship. The petitioner.
Petitioner has made this complaint before the
Before
respondent
the
number 5,
respondent number 5.
saying what?
Implicating certain individuals, Your Lordship, certain officials of the NRA, Your Lordship, on account of corruption. That is the gist of the complaint.
Hmm.
Thereafter, his complaint was verified by the respondent number 5. Thereafter, on coming to know of situations where respondent number 5 and 6, subject to your lordship's final determination,
Hmm.
was also involved in certain unscrupulous activities, complaint was made to respondent number 1, 2, 3, and 4, who is the Central Vigilance Commission, against the respondent number 5.
Hmm.
Now, the petition, your lordship, the petitioner in the petition has claimed that till the complaint against respondent number 5 is not closed by the Central Vigilance Commission in Delhi, the respondent number 5 be kindly restrained from acting on any complaints that comes before him. When this matter was heard, your lordship, this honorable court did not issue notice on the same day. The honorable court, your lordship, it stated.
No,
that-
no,
yes,
just
yes,
a minute. This complaint was made before respondent number 5.
yes, initially, the first complaint,
Initially.
your lordship.
Then what happened? Who has been restrained to look into the complaint?
Thereafter, your lordship, thereafter, your lordship would see page 49, your lordship would come for a moment to page.
Come to the
40. Yes,
pages,
yes, yes.
give me the gist of the
Yes,
matter.
yes. Thereafter, your lordship, there was a complaint against respondent number 5
Hmm.
by the petitioner.
Hmm.
It's a second line
Right.
of
So
complaint.
the petitioner first submitted a complaint against somebody else
against somebody else.
before
Thereafter,
respondent number 5,
yes,
and then submitted a complaint
Yes.
against respondent number 5 to
Five.
somebody else.
yes, yes.
All right.
That is the gist of the matter.
Hmm.
The prayer that we sought in the writ petition, your lordship, is
Hmm.
that till the complaint against respondent number 5
Hmm.
is not disposed of by the Central Vigilance Commission,
Hmm.
the respondent number 5 be kindly restrained from carrying out his duties as a Central Vigilance Officer in the NRM.
Hmm.
That is the gist of the matter. We have based our matter, your lordship, on certain circulars that dictate the functioning of a Central Vigilance Officer.
Hmm.
Now, once notices were issued, respondent number 5 and 6 and 1, 2, 3, and 4, your lordship, they came back with an affidavit stating certain the fact that the petitioner has approached this
But how
court.
can you ask for these directions from the court?
Exactly.
These are their internal matters.
These are the internal matters. in fact.
Who are you?
Yes.
You can't ask the court to pass
Yes.
orders, who should discharge what due. What is the right of yours that has been violated?
The right of mine which has been violated is that my complaint should be disposed of by the respondent number 5 as well as respondent number 4.
It is up to them.
That is my right to be,
It is up to them.
my legal right to be considered and for disposal
You
of. the
don't
right,
have
your
any
lordship.
legal right. If you're alleging any cognizable offense,
Yes,
you lodge an FIR. Only if the FIR contains ingredients of cognizable offense
yes,
and the police fails to register it,
yes,
the question of courts coming into play will come.
yes.
Other than that, this will create a chaos.
Yes.
Anybody for any reason may come and file a writ petition and say, stop him from doing this duty, ask him to do.
Your
This
lordship
is not
very-
the ambit of court's
Your lordship is
jurisdiction.
very right. Your lordship is
We
very
don't
right.
get into all these
In
things.
fact, this is the observation which was observed by this honorable court on the first occasion.
Which
Thereafter,
occasion? Let us see which order.
Your lordship, this matter was heard twice. Notices were issued on 12/6. Before that, the matter was also heard on 9/6/2023.
Hmm.
With this court, your lordship was reluctant to issue notice and interfere in the matter, as your lordship has correctly pointed out. Thereafter, your lordship had so shown instances where this honorable court can actually interfere in the discharge of the duties of a Central Vigilance Officer. It was only after that account that this honorable court had issued notices. Now, what is relevant, your lordship would see, kindly see, your lordship, that bearing aside the primary aspect of your lordship observation, I'm not disputing that. I cannot dispute your lordship observation. Absolutely not, your lordship. But there are certain accusations which have been made against me, which needs to be rectified. Your lordship will dismiss the petition on the next date, your lordship. But there are certain matters that we need to bring on.
We'll not dismiss it now, but we'll dismiss it after 10 minutes. You make up your mind, you can withdraw and avail other remedy, or I will pass a reasoned order, in which case things could be completely closed for you.
Your lordship is. very-
There are 3 reasons why these matters cannot contain. This for some reason, for some person, may turn out to be abuse of the process of court.
It can as well. Yes, your
See,
lordship.
the problem is, these are all internal matters, which
Yes.
is, this is what, when, NRL, normally got, Stefani. It is their internal matters. Once you point it out to someone, if the authorities feel there is no merit in your complaint, that's the end of the matter.
That should be.
That's the end of the matter.
That's the end of the matter.
The only other option is if somebody has indulged in commission of an offense, which is cognizable,
Yes,
then there is a procedure prescribed under the law.
yes.
That you have to invoke it by doing the right thing, not by filing a writ
No,
petition.
absolutely,
So
absolutely.
there
In
is
fact,
no other,
yes.
no third view is possible here.
the,
You can get 15 minutes if you want. Beyond that, I can't give you more time.
Your lordship will
15
grant,
days time, minutes time, you apply your mind.
lordship will grant, I absolutely, in fact, your lordship is very correct. I cannot dispute your lordship's point of view here. Your lordship will grant me 1 day, your lordship, 1 day. If not at all, your lordship, I'm under instruction of my senior.
Mr. Chaudhary, let him have on Thursday.
On Thursday,
And
on Thursday.
but Mr. Sharma,
Yes.
you are free to argue.
No,
But if you argue full-fledged, then I will pass a full-fledged order,
yes,
which may also raise issues of cost.
yes, yes.
Be very
Yeah.
clear.
No,
And
your
the
lordship is
cost
very
will be
correct. It's an internal
substantial.
matter. It's an internal.
These are not
matter.
matters that people should have been bothering the
Yes.
Heat court.
Yes,
We are trying to deal with people who are marginalized,
Yes,
not
yes.
getting their salary,
yes,
out of their job.
yes, yes.
My lord,
Their
by
houses are
statute,
broken down.
by statute, forums have been created and they are only doing their job. I do not know why they want a continuing mandamus. Something like that only, my lord.
No, anyway, he has a right to argue, but
No,
these are
absolutely.
serious matters.
Yes,
We'll
yes,
take a serious. view.
Yes, yes, your lordship.
On the request of Mr. M. Sharma, let it counsel for the writ petitioner, this matter is directed to be posted again day after tomorrow, that is give the date as a fixed item. Mr. K. M. Chaudhary, Learned Senior Counsel assisted by Mr. H. K. Das is present on behalf of respond
For
numbers
5 and 6.
5 and 6. 1, 2, 3 and 4. Mr. K. K. Saraswat, Learned CDC has appeared before, has appeared on behalf of respond number 1, 2, 3 and 4. You come prepared.
Yes,
I am willing to hear you,
yes,
but you have to hit the nail on the head.
yes, yes.
Otherwise, there will be consequences. Court's time is very important. We are struggling, we are working round the clock to give relief to people in need. Any luxurious litigation without any
Absolutely. That was
firm
not-
basis, our legal service authority may be happy to get about 2 lakhs as cost. Yes.
May I please your lordship, that COVID matter lordship, that ex gratia 50 lakhs of rupees lordship. On last occasion, lordship asked them to produce record regarding the decision making that they will not pay the ex gratia lordship.
Well, the state of Assam in the revenue,
Mr. Das, you must have your conferences outside the court. This is not a place to have conference. Tell him to be water.
the issue raised here is that, my lord, the revenue department, my lord, they issued a notification, thereby, my lord, granting an ex gratia of rupees 50 lakhs to all the frontline workers, my lord, who were engaged in COVID duty. Now, my lord, the petitioner laid a claim before the authority seeking a relief of rupees 50 lakhs in terms of the 2020 notification. Now, that was kept pending. In the meantime, my lord, that 2020 notification has been superseded, it has been cancelled. Now, on the last occasion, my lord was pleased to, my lord, direct the writ petitioner that she may not be having a surviving cause of action in this writ petition. Nonetheless, we were directed, my lord, by this honorable court to get hold of the records. My lord, I have got the digitized copy of the records.
She is receiving compassionate family pension lordship.
All other schemes are there in place, save and except only this one.
Then you want to pursue it, we'll close it and keep the issue open to be decided in another. You are receiving compassionate family pension.
Pension, that has
You
already
can't
been
have two reliefs.
lordship.
Compassionate family pension, health scheme, then my lord, other insurance scheme, all things are there, save and except this rupees 50 lakhs.
That may be reflected in the order lordship, that there are some other relief also, because lordship, I have 2 minor children who is living with me, and at this age lordship,
No, if you want to withdraw on your own, then it's fine. Otherwise, we'll admit it and post for hearing.
lordship,
This matter-
I'm not going to withdraw
Alright.
lordship.
All right. You have filed your pleadings?
No, my lord, from time to time, we have been filing reports, status report. Now the fact remains that, my lord, this notification has been cancelled. To that extent, if my
No,
lord,
Mr. Bhattacharya, you see, this was based on cabinet approval, right?
yes,
So when you pass a resolution on the cabinet, which is, we are in a Westminster form of government, right? So the cabinet is the highest body on decision making in matters of policy.
my lord.
Once that decision is made and it is formally expressed by the government by a notification, this gives rise to certain legal issues. You can't just withdraw it.
Right.
You can't just withdraw it. We have to therefore see whether this withdrawal in any manner infringes the right of the petitioner.
True.
I have seen there is no pleadings in the petition, and she may or may not be able to argue at that length. But without the assistance of a counsel, it will be very difficult.
No, then my lordship will kindly give me the liberty to bring everything on record regarding the decision-making process by way of an affidavit.
Under which principle you are claiming that your rights should be enforced? Which principle?
Lordship, they have promised lordship on that period of time. It is admitted fact, they are admitting.
What is the legal principle? That's what I'm asking you.
Lordship, there is a
You are arguing a matter in the High Court.
lordship.
Don't argue like Munsif Court. Which is the legal principle?
Lordship, it was their notification
Which
that
is the legal principle? We have to be governed by some principle of
Lord.
law. This is a court of law.
lordship,
It's not a court of fact. They
lordship,
have issued a notification, they have withdrawn it. These are all facts.
lordship.
You are saying they can't do it. What is the principle under which you are asserting your claim?
Lordship, in that case, lordship, you kindly give me some
What
time.
kind of, you are in the High Court, you are arguing matters without
Yes,
addressing the court on any legal issues?
Lordship.
Then why should we entertain? We'll close it by keeping the
No,
matter
no,
open.
lordship.
No, this is, you see, you people must understand, this is
Lordship.
serious business.
Lordship.
5 days, one day you will come, say something, the other day court asks something, you will take time. Then the other day, next question comes, you will again take time. We can't go on like this.
No.
You have to be prepared, and if you are not ready and capable of handling these matters, then you must seek help. You will not be able to answer any of the 10 questions I have to put. And 10 times the matter will have to be adjourned. Each time I ask a question, you will have to go back. Because you have not read the principles. You have not done any studies. Is that correct? Yes or no?
I'm studying.
Have you
lordship.
done your research work in the matter?
I'm studying lordship.
You are studying. You have started or you will start now?
No, lordship, I'm
You have
studying,
started.
Studying.
You have or you will?
No, I have started,
You have-
lordship.
you
I'm
have.
trying to help.
Okay, what are the things you have found so far? Your study has revealed what?
No, lordship. They have promised this, and during the
So I
pendency
am
of
asking you, what is the principle? They have promised and they have said we'll break the promise. What is the problem?
during the pendency of this writ petition, lordship.
Promises can be made and broken also.
Lordship.
You know, they have made it and they are now going back on it. So they may again make it and again go back on it. What is the legal principle? For the courts to step in and say that no, you can't do it. It has to be based on some legal principle. What is that principle?
Lordship, in that case, lordship, provide me some time.
All right, heard Mrs. Kanangurani, counsel for the petitioner, also heard Mr. R. Bapujani, Learned Standing Counsel, Finance Department, Assam, who submits that taking note of the grounds urged by the petitioners, it would be necessary for him to file a detailed affidavit for which 6 weeks time is required. Posted. The prayer is not opposed, hence the same stands allowed. Let the matter be listed again after 6 weeks. In the meantime, counter affidavit on behalf of the respondents be brought on record. Please do some research study. You are in a high court practice.
Lordship.
You must know what you are telling the court.
Lordship.
May I get back that record, my lord? May I get back that record?
Yes, yes.
I'm so obliged.
Deeply obliged.
For hearing item 5,
May it please your lordship. Lordship, R. Muzumdar is on legs. He is in court number 13. Kindly pass over for timing.
What has happened in this case?
Lordship, we were supposed to give the instruction, Lordship.
What has happened to the instruction?
Lordship, we have received the instruction.
What is it? Let us see. Have you received this? You make a photocopy. Can you give him a copy?
Yes, yes.
You examine this. We'll take it after 2 weeks. Mr. Your name, please?
And Ali.
And
Ali.
Ali Learned Counsel is present on behalf of the petitioner. In terms of the order dated 22/8/2023, Miss
P. Rava on behalf of Mrs. Agar.
P. Rava, appearing on behalf of Mrs. A. Gayan Learned CGC, has produced a copy of the written instruction dated 6/9/2023, indicating the various heads on which the petitioner has payments have been released to the petitioner in terms of the earlier order of penalty of compulsory retirement. Full stop. Mr. Ali seeks to try to examine the same and come up with a response from his client. In view of the above, let this matter be listed again after 2 weeks. A copy of the written instruction dated 6/9/2023 be furnished to Mr. Ali. Give him a copy.
Item 6.
And six, Lordship, my learned friend have filed the affidavit today, Lordship. I have received the copy. So I need some time to my lord. Obtain instruction, my lord.
You filed it today.
Yes, my lord, there was some difficulties. When the petitioner came and.
All right. He wants time.
No, no, it's a short date, my lord.
All right, 2 weeks. Heard Mr. AJ Learned Counsel appearing for the petitioner. Also heard Mr. J. Henry Learned standing counsel. You are appearing standing counsel.
Lordship.
Revenue and Disaster Management Department, Assam, who submits that in terms of the order dated 14/3/2023, the writ petitioner has served a copy of the additional affidavit upon him only this morning, and therefore at least 3 weeks' time be granted to seek instruction and file rejoinder if so required. Mr. Ati has also confirmed that the additional affidavit has been filed only this morning. In view of the above, this matter stands adjourned for 3 weeks. Legislature to list this case again after 3 weeks by tagging the affidavits filed by either sides in terms of the orders of this court.
Oblige, Lordship.